Hello, my name is Michael Tessara and I prepared this presentation entitled Out of Touch, and I'll be looking at the case of ACCC and Mazda Australia Proprietary Limited. And this is a full federal court decision which looks at appeals from both Mazda and the ACCC. And the reason I call it Out of Touch is I think it just shows how a number of judges in the federal court are just really out of touch with the right way to apply statutory unconscionability under the Australian consumer law, and particularly the majority judgment of Mortimer and Halley is a big disappointment with the way they look at all the factors and conclude that the conduct of Mazda wasn't out of kilter with the community expectation of appropriate commercial conduct. By the same token, the dissenting judgment of Lee is particularly good in terms of really getting to the heart of the right way of interpreting these particular provisions. Now, a bit of background about myself. I'm a competition consumer lawyer and I've been running my own practice to sales legal consulting for the last 15 years. And I help companies with competition and consumer law matters. I also do a bit of consultancy work for various companies like Walters, Kluwer, CCH, LexisNexis. Prior to that, I worked with ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline, I'll start with a very quick summary of the primary judge decision by O'Callaghan. Then I'll look at the appeal decision. There's two elements to that. The first is the Mazda appeal and then the ACCC appeal. Be focusing primarily on the unconscionable conduct arguments and then finish with some commentary. Now, the initial case by the ACCC alleged that between 2015 and 2019, Mazda engaged in various breaches of the law in relation to 9 specific Mazda customers. They alleged misleading conduct under Section 18 and also false and misleading representations under Section 29(1)(m). That related to misrepresentations about the existence, exclusion, or effect of various rights, specifically consumer guarantee rights. And they also alleged the same conduct constituted unconscionable conduct in breach of Section 21 of the ACL. Now, the ACCC alleged specifically that Mazda were claiming that certain major failures weren't major failures, so certain faults didn't constitute major failures and thus result in the consumer having certain consumer guarantee rights. Furthermore, that consumers were not entitled to a refund and replacement at no cost. Also, that Mazda had this right to repair vehicles rather than providing a refund and replacement. Furthermore, that when considering this whole issue of consumer guarantees, Mazda was able to take into consideration both the age and mileage of the vehicle. And finally, that a major failure only arose where there was a failure of a major component of the vehicle. In relation to the unconscionable conduct case, it was notable that the ACCC effectively ran 9 individual unconscionable conduct cases rather than alleging a system or pattern case. And that was particularly surprising given the number of common features there were between the 9 individual consumers. Now, the decision of O'Callaghan at first instance was the ACCC's misrepresentation cases were made out. Mazda interestingly had failed to follow its own internal policies. So it had these internal policy documents which set out the law in relation to consumer guarantees quite accurately, and also identified when a particular failure in a car would be considered a major failure, thus giving a consumer the right to a refund or replacement. And they didn't follow those policies. The staff who were dealing with these complaints just ignored those policies routinely. Rather, Mazda had this view that they had a right to repair the cars rather than provide a refund or replacement. And in many cases, they're repairing cars numerous times, replacing engines, replacing transmissions, whilst insisting that it isn't a major failure. Now, in the unconscionable conduct case, the ACCC was unsuccessful, and this is because O'Callaghan concluded that the conduct was not sufficiently divergent from community standards of acceptable business conduct so as to constitute unconscionable conduct. He described the conduct rather as appalling customer service. So on appeal, there were 2 primary questions. The first was whether the conduct was misleading, deceptive, which is the Mazda appeal, and secondly, whether the conduct was unconscionable, which is the ACCC appeal. And the 2 appeals were interrelated, so the same facts were relevant to both the misrepresentation case and the unconscionable conduct case. So just turning to Mazda's appeal grounds, they're quite a big production, 38 pages of appeal grounds, 38 numbered grounds of appeal, but there were many sub-paragraphs. So I think when you add it all up, it's probably over 100 appeal grounds. And it actually took the appeal court 148 pages of a 198-page judgment to deal with all those appeal grounds. And I must say, they really were pretty hopeless appeal grounds. There didn't seem to be a lot of merit in many of them. And I was quite surprised at some of the grounds that they raised, which seemed to go against many years of case law under these particular provisions. To give you a flavour of some of them, here's one of their appeal grounds where they allege that when determining whether a representation was misleading, the judge should have taken into consideration the knowledge of the particular individual to whom the representation was made, whether they knew the truth of the matter, whether the individual was likely to be misled, also whether they had received the advice from any agencies such as ACCC or Fair Trading or from a lawyer, for example, and if they had received such advice, that this would mean the representation was not misleading. Now, that was a really surprising submission to make, given all the case law over many, many years, which indicates that the knowledge of the individual consumer is irrelevant. It's not a relevant consideration to determine whether a representation is misleading. It's clear that the judge's role is to look at the representation and work out whether a reasonable consumer would be misled by that particular representation. It's not a case of looking at into the mind of each individual consumer. So it was very surprising that was put forward to an appeal court as a ground of appeal. It seemed to have no merit whatsoever in my mind. Another one was the fact that if representations are transitory or ephemeral or could be dispelled quickly or clarified or corrected in the same conversation, then they wouldn't be a misrepresentation. Again, this is just quite a remarkable submission to make to an appeal court, because the case law is quite clear that, again, you look at the representation and you try to work out whether a reasonable consumer would have been misled by what was said in that representation. Whether it's transitory or ephemeral, dispelled quickly is irrelevant. So again, I was very surprised that these submissions were made, and fortunately the court was able to dispel all these appeal grounds quite efficiently. Like, it took them 148 pages, admittedly, but they're being dispelled quite quickly by the court. Now, turning to the unconscionable conduct case, the ACCC made 4 primary claims. The first was that the Judge O'Callaghan had failed to use the correct judicial technique in assessing whether conduct was unconscionable. Furthermore, that he had failed to take relevant findings in relation to misrepresentation case into account when he was looking at the unconscionable conduct case. He didn't give sufficient weight to the relevant findings which he'd made. And finally, he did provide adequate reasons for the conclusion that the conduct was not unconscionable. So what the majority decided, which was Mortimer and Halley, was that the primary judge did not provide sufficient reasons. It was very sparse in relation to his reasoning as to why he rejected that unconscionable conduct case. And as they note there at paragraph 518, is that the Callaghan didn't actually explain what he meant by the descriptor appalling customer service. What did that actually mean? Furthermore, they concluded that the allegation that the judge had actually put aside a strong body of evidence was upheld. Effectively, he had put aside a strong body of evidence on the misrepresentation case, which the ACCC alleged was also relevant to the unconscionable case, and he failed to provide an intelligible explanation as to how that strong body of evidence didn't support the unconscionable conduct case. And they said that it appeared that he really just provided a personal, intuitive assertion that the conduct was not unconscionable. So I think you'd probably say Callaghan did a pretty poor job on the unconscionable conduct case. Now here the interesting thing was that the appeal court could have decided either to remit the matter back to Callaghan to have decided according to law, or they could decide it themselves. Really, probably, I think the appropriate thing would have been to remit it, but the majority, Mortimer and Halley, decided that they had sufficient information before them to decide the issue themselves. And probably not unsurprisingly, they backed up the primary judge's decision that the conduct did not diverge sufficiently far from community standards of acceptable business conduct to constitute unconscionable conduct. And they did, in paragraph 574, put the word sufficient in italics. And I think they're suggesting that while the conduct did, or they actually state later on, that whilst the conduct did depart from the norms of acceptable commercial behaviour, it wasn't quite far enough away to tick the box in terms of unconscionable conduct. So they noted some things that the ACCC established in its case before the primary judge. For example, that even though Mazda had its own guidelines spelling out what would constitute a major failure, which included the failure of an engine or transmission, the staff routinely ignored those guidelines and told consumers they weren't entitled to a refund or replacement. Also, they noted that Mazda engaged in these protracted commercial negotiations to try and get consumers to accept a payout which was significantly below the price they paid for the vehicle. They performed extensive vehicle repairs, sometimes over a number of years. And they're saying that all these things were serious and reflected poorly on Mazda. However, the ACCC's case fell short because it didn't establish a few things. Firstly, it expressly disavowed an allegation of dishonesty and fraud. Secondly, contrary to the Lux case, the ACCC did not allege that Mazda engaged in conduct that was deceptive in the form of a ruse or stratagem. Also, it did not advance a systemic conduct case. So, for some reason, failing to allege a systemic conduct case reduces your ability to establish unconscionable conduct in relation to specific consumers. Also, they said that the case that the ACCC proposed to run, which was to run expert evidence to prove that the failures of the 9 consumers' vehicles were a major failure, the fact that they abandoned that case meant that the ACCC were unable to establish that the consumer actually had an entitlement to a full refund or replacement vehicle. So these are probably some explanations as to why the ACCC's unconscionable conduct was unsuccessful. And I must say, highly unpersuasive reasons for that conclusion. They also made this strange point that because there was an express representation case made out, rather it was an implied representation case, that wasn't quite as serious as it could have been. And so that meant it was less likely to be unconscionable. So if you make an express misrepresentation to consumer, that could be unconscionable. But if it's only implied representation, well, that probably falls a bit below the test required for unconscionable conduct. They also said that the failure again by the ACCC to run this case to establish that the consumers were entitled to a refund meant it was less likely to succeed on establishing an unconscionable conduct case. So they're suggesting that had that been established, the conduct would have been more serious, but by failing to run that particular case, the objective seriousness of the breaches was materially diminished. So they're trying to think of a lot of reasons why the conduct really isn't that bad. And that is disappointing because I think community would consider this to be very below the standards expected of a large commercial operation such as Mazda. They also made note of these red flags that the ACCC identified about the seriousness of the faults, the safety concerns of consumers, and they're saying, well, we can't put a lot of weight on that because the primary judge rejected the ACCC's submission that Mazda did not take the consumer safety concerns with the vehicle seriously. So the primary judge didn't agree that Mazda had not put weight on the safety concerns of the consumers, but the fact remains that these vehicles were dangerous. There were vehicles going into limp mode on freeways and motorways, and that's clearly highly dangerous. And that was something that was established on the facts at the primary judge level. And then they made this conclusion, which I found quite surprising. They draw attention again to the failure of the ACCC to run a system case. And then they said that the conduct of Mazda could not be characterised as tricky or sharp practice, predation, exploitation, unfairness of a significant order, an absence of good faith, or an exercise of economic power. And I think that conclusion is well open to being challenged, because there was evidence established, or facts established in the case, that Mazda representatives had misled consumers about various issues in relation to their claims. So there was definitely some trickery. Are they acting in a predatory manner? Well, arguably they were. Exploitation, clearly unfairness of a significant order. If you're misleading consumers and making false representations to consumers regularly, that's considered generally pretty unfair. Absence of good faith. Well, Mazda had documents which told staff what would constitute a major failure, and those guides were ignored. That doesn't sound like they're acting in good faith. And clearly, exercise of economic power. You can take us to court if you want, or you can accept back this car which you believe is unsafe. So this conclusion just seemed to run entirely against the evidence that had been established in the misrepresentation case. So they ultimately concluded that the conduct of Mazda did not constitute a sufficient departure from the norms of acceptable conduct. But then they made the comment, the second part of the paragraph there, that even though they've decided that there wasn't a significant or sufficient departure from the norms of acceptable conduct, we're not saying that this conduct was consistent with the norms of acceptable commercial behaviour. So there seems to be this continuum, and for some reason the conduct of Mazda falls just below the level at which unconscionable conduct would be established. So it was against conscience, it was contrary to acceptable commercial behaviour, but it wasn't bad enough to result in a court finding of unconscionable conduct. Now, Justice Lee's dissent is, I think, very well worth reading, and I think he gets it spot on. The first thing he says is maybe the ACCC was its own worst enemy by the way it ran the case. He notes that the closing submissions they filed were 300 pages long, contained 1,435 footnotes. He makes a reference to the Get Swift case, which I did look at in a recent presentation, and he describes the case as being prolix, repetitive, and complex. This is a problem that regulators have to avoid, making cases too complicated and too difficult for judges to wade through all the evidence. There's an argument that Callahan sort of ran out of puff in that particular case after dealing with the misrepresentation case, and that may have explained why he didn't do the unconscionable conduct case properly. Now, he looks at the system case that wasn't run by the ACCC, and he's puzzled why they did run a system case, because the case that actually did run seemed to identify a number of common features in relation to Mazda's conduct. And he lists them there. There was common features of no proper or genuine consideration of the consumer's entitlement to a refund. There seemed to be a culture in Mazda to deny requests for refunds or replacements and to favour repairs. The consumer advocates, as they were called, routinely made false and misleading representations to consumers. It was established that Mazda did not appear to take consumers' genuine safety concerns seriously. And finally, it was clear that Mazda was in a completely dominant bargaining position. But these are common features. So I guess the question at least sort of suggesting is, why didn't the ACCC run a system case? Then he looks at the case of RC, and this was a particular consumer, and this is all stuff that was established by the ACCC before the primary judge. Firstly, she raised concerns about a vehicle. She raised serious safety concerns. Her car was off the road for long periods of time. It was a brand new car too. It was off the road for long periods of time. They rejected her requests for a refund repeatedly, and they gave no proper consideration to her entitlements under the consumer guarantee laws. They sought to dissuade her from continuing with requests, seemed to offer her some money to get her to go away. They falsely told her that age and mileage was somehow relevant to determining if she had a remedy under the ACL. Mazda was in a totally dominant bargaining position. They obfuscated her requests, did not take her safety concerns seriously, and finally they placed unfair and unreasonable commercial pressure to accept the offer. And that was all established on the evidence. And he's saying he can't understand how isn't that a serious departure from proper commercial conduct? If all those factors have been proven, then that has to be a serious departure from proper commercial conduct. Clearly, there also an element here that this conduct could correctly be characterized as subterfuge. And that was a view that the primary judge reached. And clearly there was a want of appropriate candor. Maybe there wasn't deceit, which is obviously a higher standard, but there was a definite lack of candor. And he's asking the question, how is this not a departure from community expectations of proper commercial behaviour? He also notes that the pressure that was put under the consumer being required to drive an unsafe car, to be told that the only way she could get satisfaction was to commence litigation against Mazda. She was under this pressure that if you don't accept Mazda's outcome of a bit of money, then she might be left with nothing but a car she regarded as unsafe. So he's saying, how is all this stuff not unconscionable? He also doesn't agree that the distinction drawn by the majority between implied and express representations is appropriate. He actually thinks that implied misrepresentations are probably just as bad as express misrepresentations, if not worse. But again, it's introducing this extra requirement in interpreting the statutory text, which is not included in the statutory text. There's no reference to the type of misrepresentation that needs to be made for unconscionable conduct to be established. And here he makes a very good observation that the courts have tended to attenuate the concept of statutory unconscionability and fail to appreciate its potential breach. And this is the whole point of the talk here, that they're out of touch. They don't understand what the point of the law is. And the second observation there, that the courts are overcomplicating their evaluative tasks and becoming distracted by seeking to characterise conduct as being of a nature that can be described as malified, dishonest, predatory, exploitative, unfair. So they're using these other terms to try and work out what unconscionable means rather than interpreting the provision as it's written. And that's making the decisions incorrect and really out of touch. And I think this is a really good quote, and I read it all. The pervading influence of the provisions enacting this norm might be seen generally as a reflection of social attitudes that have heralded a retreat from legal formalism on several fronts. And in many ways, the existence of the norm reflects community of expectations of acceptable commercial behaviour. That's what the courts have to realise. This is a new norm that's been created, and the courts have to apply this norm as it's written, and not to import all these other concepts in trying to interpret this provision. And then it's not as simple as that. There is a continuum of conduct that can contravene these norms. At one end is wicked, predatory, highly immoral conduct, and at the other end is guileless conduct engaged in by someone trying to do their best, and which involves innocent but mistaken conduct. So there's a continuum, and you have to work out where the conduct fits on that continuum, and there's going to be a point below which it's not unconscionable and a point above which it's going to be unconscionable. Now, the problem here is that the majority, in his view, and I think this is implied, has got the analysis wrong. This conduct clearly goes beyond the level at which conduct would be unconscionable. He says it's simplistic and wrong to point to all this misleading conduct made by a major corporation to consumers and say it's not against good conscience. How can it be possibly concluded that making misrepresentations, false representations to consumers is not unconscionable? How can that conduct be rightly characterized as misleading and seriously wrong, but not of such a character that it's contrary to the prevailing norms of conducting Australian business? How can it be considered as conscionable conduct? And he cannot accept that the conduct summarised in relation to RC, the consumer RC, is anything other than a marked diversion from what is right and proper. Clearly, if you're misleading your consumers, you're forcing them to drive an unsafe car, you're basically pressuring them to take legal action against you if they want to assert their rights, you're not genuinely considering their concerns. How is that not a marked divergence from what is right and proper? And I guess the final thing is, really, should the majority have decided this case, or should they send it back to O'Callaghan to decide the case according to law? Well, his view is it should have been remitted, and I agree with him. I think it should have been remitted back to O'Callaghan rather than trying to make a decision on appeal that reaffirmed O'Callaghan's unexplained decision that the conduct was not unconscionable. It really should have been sent back. Now, just some commentary. The first point is I thought Mazda's appeal grounds were quite hopeless, and it is concerning that a major corporation would be running such meritless appeal grounds and really wasting everybody's time, wasting the ACCC's time, wasting the court's time. And I was surprised that the court was not more critical of the lack of merit in those appeals. Secondly, the conduct by Mazda as established at the primary judge level was very poor. He established extensive misleading and false representations by Mazda to consumers. Clearly, a lot of the representations made were false. There was deception. There might have been fraud, but there's deceptive comments made to consumers, and that has to constitute unconscionable conduct. The majority decision of Mortimer and Halley is clearly wrong in my view, and is disappointingly wrong because it just shows how out of touch so many federal court judges are. They're not applying the terms of Section 21 correctly. They're importing all these other concepts about implied representations and whether things are fraudulent or whether there's predation, all these other ideas, rather than just applying the provisions the way they're written, and also just looking at the community expectations of appropriate commercial conduct. And that's where they're out of touch, because I think any consumer that you asked about the conduct of Mazda would immediately say the conduct is well outside the range of appropriate commercial conduct towards consumers. Misleading consumers about so many issues is not appropriate commercial conduct. Clearly, Lee got it right. His approach to it is the right way to approach it. His conclusion that the conduct had to be unconscionable was also correct. The big concern I have here is whether the ACCC is actually going to appeal this case to the High Court or not. They might conclude this is not the right vehicle, that's probably a bad pun, the right case to put to the High Court, but really something needs to be done at the High Court level to just help the judges out in understanding how to apply the test of what constitutes community expectations of appropriate commercial conduct, because it seems to me that the judges keep importing all these irrelevant considerations and concluding that conduct is not unconscionable when it clearly is. So that's all I had. Hopefully that's been helpful. It's very disappointing, the majority judgment in this case, but I think Lee's judgment is well worth reading. And if you have any questions about this presentation, feel free to give me a call or drop me an email. Bye-bye.